Good morning, ladies and gentlemen. Welcome to the 11th in the series of our weekly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard, and I am the Head of Marketing here at Sintons. As I've said 10 times, and as I say every week, thank you once again for joining us, for all the questions you've sent in during the week. Just for tuning in, and we've got a record amount of people signed up this morning. The numbers are staggering. So generally, we were just talking, the team and I were just talking before, and we're just so grateful for you all tuning in, and just really pleased that we're still providing value to you with these sessions coming to you each week. As with previous weeks, the employment team are going to answer 3 questions. Our speakers today are Head of Employment Keith Land and Associate Catherine Hope. So just moving the slides on there so you can just see all our faces and the questions that we're going to deal with today. So without any further ado, I'm now going to pass you over to Catherine. She is going to deal with question 1 of 3. Catherine, good morning, and over to you.
Thanks, David, and good morning, everyone. Thanks for joining us again this Friday morning. And again, the sun is shining. It seems to come out every week for us. So we have a number of questions again, and I'm going to start off with one about changes coming in tomorrow. Now, someone asked about the changes to returning to the workplace. So I'll cover what we know so far and some of the options that employers might be looking at. Now, earlier in the month, Boris Johnson announced that there'll be an announcement in terms of an update to guidance tomorrow in terms of employees returning to the workplace and what employers can do. And what he said was that employers will be in a position where they can ask those employees who have been working from home and have been able to do so during lockdown to return to the workplace, as long as that workplace is set up in terms of measures to make it COVID secure, and there are measures in place in terms of social distancing. What he also did say is that employers will have the discretion to decide how they want things to work in terms of how their employees will work safely. And for some, that may well mean that their employees continue to work from home. So, of course, we will need to see the detail of what comes out tomorrow, but in terms of the options of the kind of things that employers might be looking at, or where they've already put things in place, I'll just go through some of the things now. It might be that for some employers, the way they're organised, the way your organisation works or the way your business works, your employees have been working from home and it's working well for you, and you decide that actually, in light of the health and safety measures that you need to put in place in order for staff to come back, you're deciding that actually you're going to continue, keep things as they are, and employees are working from home, and you're going to keep the workplace closed for the time being. And that's something that employers might well decide to do. What I would say is you need to then think long term about your employees' mental health, support in that regard, particularly for those employees who are working in isolation, and making sure those lines of communication are open and working appropriately. You also might find that actually there is an increase in requests in terms of suitable working equipment where employees are working at home for a longer sustained period. What I would say as well, you might in that situation have employees who are really struggling to work from home, and it might well be that some employers decide to facilitate them working in the workplace. Another option is employers might think about partially reopening and having employees attend on a voluntary basis. It may well be that you're deciding that you want to test the water in terms of the measures that you've put in place with a reduced workforce to see how that goes. And a lot of employers will already be doing that in preparation for the workforce to come back in larger numbers. Again, that's something to think about, and some employees might well be putting that in place now. Some might think that's something that they're going to do later on in the year and see how things go. Finally, there are employees who will make the decision that they need their workforce back in one place or changes in some form. And the nature of their business or organisation means they need people working together, and they need to be seeing people on a day-to-day basis, and that change needs to be made. What I would say is having a blanket requirement for employees to come back to work without any consideration at all for ongoing personal circumstances and how the impact of continuing restrictions and what's available is a risky decision. You need to look at personal circumstances and be flexible in terms of having those discussions with staff. The main 2 things to think about, there will be a number of different personal situations, but the main things that we have, of course, touched upon in more detail in previous sessions, but obviously thinking about your staff who fall into those vulnerable and extremely vulnerable categories. Now, of course, the advice in terms of shielding does change from tomorrow, but you will need to make sure you're keeping up to date with the Public Health England guidance in terms of those particular categories of employees who fit into those categories, and the guidance in terms of them working and attending the workplace, and any additional measures that you are expected and required to put in place. Second main one is you're going to come up in relation to ongoing childcare issues. So your employees who have childcare responsibilities and don't yet have the normal childcare assistance and facilities in place that they would ordinarily have, particularly with the ongoing summer holidays, and we're not back to normal in terms of what's in place, but also support from family members. Talk to your employees about those situations and look at what their situations are and work something around that flexibility. Other things to think about, just on a final point, is public transport. Although there aren't any, the restrictions have been lifted, it may well be that it's appropriate to look at allowances in terms of people getting to work at peak times, but also making sure they can comply with their commitments in terms of childcare, whether that be getting their children or young babies to nursery, if there are still differences in terms of the opening times that affect their working times and things like that. So do have those discussions. So that's just things to look out for. Do look out for what comes out tomorrow, and we'll obviously come back to that point in terms of what comes out. So I'll pass you on to Keith, who will deal with the second question.
Thanks, Catherine. It's a really interesting debate because I was at the swimming pool this morning with the kids. I wasn't in, they were swimming. Lord knows what I'd look like in a pair of Speedos, but they're again, particularly after lockdown. Anyway, I was chatting with one of the other parents, and we at Sintons have sort of got a policy where, subject to everything that Catherine's talked about, we're trying to move people back into a more regularised working environment as from next week. And this individual works for a very large tech savvy company who was saying that they're not going to be back in the office or the workspace until September as a minimum. So it really depends on your organisation and what you're doing. So don't think there is one rule that has to apply and one size fits all. It's not the case. You've got to make your own decisions, as bearing in mind the guidance that Catherine's helpfully taught through. Employees in mandatory quarantine. Oh, right. This one has some real personal application to me because I'm due to go to France this afternoon. Given that Spain's been locked down at a moment's notice, this could well apply to me in a couple of weeks' time, depending on whether this second wave keeps moving across Europe. I've got to say Spain's cases seem to be springing up much more rapidly than other nations like Germany and France, but they have been mentioned by the government. So I think this is it's a challenging one, really, because let's look at holidays. People have a right to take holidays in their contracts, don't they? People have all been locked down for somewhere between 4 months now. People are pretty fed up. They want to get away. It's helpful to the economy for people to be booking holidays because the travel sector's been battered by what's gone on. But looking at your businesses, any holiday is subject to operational requirements, and really somebody going abroad when they can't work at home or something like that might face you with a position that if they can't work when they come back because they've been quarantined, what do you do? Well, I think it's not unreasonable in the circumstances if somebody wants to book a holiday to understand where they are going and are they going to Spain, and therefore are they going to definitely be quarantined. Any holiday is subject to operational requirements, and if it's the case that they're then going to be quarantined and you can't operate, you would be in your rights to refuse that holiday. There's some things that you have to bear in mind. At the end of the day, if you do operate your organisation in that way, People have a right to take their working time holidays within the year in which it's taken, and then if they don't, those holidays, and that's 28 days per annum inclusive bank holidays, and if they're prevented from taking them by an employer, will continue to accrue. And at that point in time, they will be there for them to take it another time, and that could present you with other problems. And so I think there is a reasonable balance to be struck as the honest answer. What I would also say, if people have already pre-booked in the last 4 weeks or 5 weeks to go to Spain and they're now quarantined, are you really going to prevent them from taking their holiday? Because that could be a breach of the implied duty of trust and confidence. What are you going to do in the circumstances? Well, I think those decisions, again, are decisions that you need to take having regard to the operations of your business. And if you were willing, if you were minded to block a holiday, you're possibly in the current circumstances within your rights to do that. Operationally speaking, they're all subject to any application of holidays is subject to operational requirements. But if you've already granted somebody a holiday and it's been approved and they're going to go to Spain, mad as that would be, because I think it disrupts all of your insurances, so I think it would be crazy to do it, then you've probably pre-approved that holiday, they're entitled to go, and what are you now going to do? Are you really going to pull that holiday? Probably not. Therefore, where do you go if, or alternatively, if somebody goes, say I go to France this evening and then come Monday before I can get back, the UK government implements a quarantine order. Well, the reality is those people have to spend their time at home. If you know they've been away, they've been to a quarantined area, I think it would be inappropriate for them to come into the workplace for all the reasons that Catherine has just talked about keeping people safe, etc., etc. It's probably then going to be a breach of your health and safety obligations for you to let them in the building if you know they have been to an area where there is an enforced quarantine. So what are you going to do with them? Well, they're going to have to be away from the business for 14 days. What does that mean? Well, I suppose it means sensible things again. Can they work from home? A lot of us have been working from home for the last 4 months, and in many respects we're working at home now. I can see Catherine's there in her bedroom. I've got my backdrop on, but I'm actually sat in my front room. Can the people work from home? If so, well, actually, they can probably still take the holiday. That's the basis on which I'm working. If I do get quarantined, I can still do my job adequately. I've been doing it for the past 4 months, and therefore it doesn't cause me a great deal of hardship. That might be different for somebody who is on a production line, for example, and you've got to you've got to operate your business in the way that you need to operate it. If they are quarantined, other things to consider, are they entitled to contractual sick pay? In most instances, I doubt it, because they're not actually sick. They're just sitting at home because they're forced to be by the government, so they probably won't qualify for contractual sick pay. They will, however, qualify for statutory sick pay. That covers the isolation of a person to prevent the spread of a communicable disease. Other options for you to consider what they do if they're off sick. Sorry, if they're quarantined and you're paying them SSP, do you allow them to commute more holiday and turn their quarantine period and get paid for it by using up the balance of their holiday for the rest of the year, so you know that person is going to be in the business and is going to be operating from, say, September right the way through to Christmas without a break? Again, you've got to consider your health and safety obligations to whether that's a safe practice, but fundamentally you could have that arrangement with an employee if it allows them to get through that period. I think that's all I had to say on that particular point. Before passing back to Catherine, I'm going to jump into another point which obviously popped out in the news yesterday. Catherine and I thought it, and David thought it would be remiss that we didn't cover this today. It's all, and you might have seen it in the news, it's all about people paying redundancy payments and notice pay on the furlough rate for people who have been furloughed, and the government brought in new legislation yesterday to put a block on that. There was a lot written about it in the press, and it was all over sort of chat rooms and things yesterday. Starting with the redundancy payment, a redundancy payment is calculated according to a set of fairly complicated legal provisions in the Employment Rights Act, which defines that it's calculated as at a specific calculation date. Okay, and that's not necessarily the date that somebody leaves their job. The most simple way of looking at it is if somebody works their notice and then they leave on, say, the 1st of September, because they've worked their notice, the calculation date for their redundancy payment is the 1st of September. Okay. However, if somebody does not work their notice and is dismissed as redundant, and they leave on the 1st of August, the calculation date is a date in the past, which is calculated by working their statutory notice period backwards, and their redundancy payment is calculated on the rate of pay at that point in time. And as you can probably imagine, there's been some debate that if that's the rate is at 80%, i.e. the furloughed rate, does that flow through to the redundancy payment? Well, my own personal view was it didn't anyway, so I'm not sure what all the fuss was about, because the provisions in the Employment Rights Act for calculating redundancy pay, if somebody hasn't been working, is you go back to the last date that they worked, and if someone's been on furlough leave, then you'd have to go back to their pre-furlough period to calculate the payment of their redundancy pay. But there was clearly some debate about it, and if you had contrary advice, I'd love to hear it. But the government, as from today and close of play today, has blocked that. And therefore, if you are going to calculate a redundancy payment for anybody in the future, it would have to be on their normal rate of pay, not the 80% furlough rate. When I say their normal rate of pay, the normal statutory cap of around 550 quid, it's somewhere near there approximately, will apply. So it's not their actual rate of pay, it's their actual rate of pay capped by the statutory value. You've then got to look at their statutory notice, okay? And are you able to pay somebody 80% when they are effectively serving out their notice, but they're on furlough leave? Again, the government's taken steps to block that. But how's it gone about it? Well, this is a fairly complex provision. Under the Employment Rights Act, there is a rule that says if somebody is entitled to only receive statutory minimum notice, and this is set out by Section 87 of the Employment Rights Act 1996, if you're on statutory minimum notice, you are entitled to be paid for the period of your notice, irrespective of whether you're working it or not. Okay? So statutory minimum notice is 1 week per year of employment, up to a maximum of 12 weeks. So if somebody has 4 years service, they have 4 weeks statutory notice, and even if they're on furlough or they're off sick and therefore not in and exhausted their right to sick pay, and therefore they're an employee but not receiving income, they're entitled to be paid, okay, in full. So applying that example here, if you had somebody who was furloughed, receiving 80% of their pay due to the government grant, or up to a maximum of 2,500, you give them notice and they're on statutory minimum notice in their contract from the employer to the employee, they're entitled to be paid in full, in my view. There's clearly been some debate once again around whether that's appropriate or not, and whether people have been paying 80%. Again, the government has moved to do that, but they have again. The next question is if somebody then has a contractual notice period that is more than the statutory notice period. So, for example, if they've been working for four years and therefore have 4 weeks notice under their under the statutory notice provisions, but their contract says they're entitled to 2 months notice, is that person again entitled to be paid 80%, or is the employer entitled to pay them 80% during their notice period, or do they have to then top up to the full rate? Well, given what the government has done to the regulations that came out yesterday and are in force from the close of play today, the government appears only to have applied the right to receive full pay to those people who are on statutory minimum notice. There is a provision in the Employment Rights Act in its section 87(4) that says the right to be paid during the statutory notice period only applies to those on statutory notice, and for those whose notice period is 1 week or more in excess of statute, then they're not entitled to receive pay during the statutory notice period. And the impact of that is, in my view, that the changes that the government make have only sought to preserve the situation that existed in the legislation in any event, which was if somebody is on statutory minimum notice, they receive full pay. But if their contract entitles them to more than statutory minimum notice, then they're potentially, the employer is still entitled to pay them 80% during the furlough period where they might be serving notice. Consequently, in short, I didn't really see the necessity for this statutory intervention by the government, because all it's done, in my view, is to preserve the existing provision. That was a very long-winded way of putting it. The provisions are really complex, unfortunately. So just go by the simple rules. Statutory minimum notice, entitled to be paid in full. If they have a notice period that's in the contract in excess of statutory notice, you might want to pay them in full, but you could get away with 80% if that's what you choose to do. I've run out of puff. I'm going to pass you back to Catherine, who's going to deal with managing grievances during the COVID-19 pandemic.
Thanks, Keith. Yeah, it'd be interesting to see. It might be the case that we don't see Keith for another month or so. So we'll wait and see what happens. Unfortunately, I'm doing a staycation this year in the lake, so not that I want to be quarantined, but going abroad.
And not that you want to get rid of me.
No, of course. Right, to finish off, we had a question about grievances and dealing with those if they come up at the moment while we're still in the midst of the COVID-19 pandemic. It's an interesting one, because it might well be that as we see the return of staff to the workforce, to the workplace, and or returning from furlough, that employers might well see a rise in grievances or concerns raised due to individuals' personal circumstances. So it's useful to think about some things to consider if you are dealing with a grievance. I'd say first things first, remember the ACAS code. Look at your internal policies and obviously ensure that they comply with the code. That's the ACAS code on disciplinary and grievance procedures. It still applies, and as you will be aware, if there's a subsequent claim and an employee is successful in that and you have not followed the provisions of the code, the tribunal can increase compensation up to a maximum of 25%. So do bear that in mind. In brief, in terms of the grievance, it's that inviting the employee to a meeting for their grievance to be heard, giving them that right to be accompanied, confirming the decision, and then giving them that right to appeal in terms of not being satisfied with the outcome. What about if you've got staff on furlough leave? Well, staff on furlough leave can still raise grievances, and they might well do. If you have individuals who are available as part of the investigation to come in an interview or to attend meetings, then by all means do that, as long as obviously if the workplace is COVID secure. If you're in a situation where that's not possible, then the meetings can be held remotely, looking at technology available. So don't just put things to one side. You need to consider how things can be managed and if it's possible. If you're actually in a case where you're actually dealing with redundancy consultation at this time, it's really important that you think about the subject of the grievance. Is it intrinsically linked to the redundancy process? For example, is someone saying they've been selected, for example, on discriminatory grounds? If that's the case, then it's going to be more appropriate probably for that grievance to be heard as part of that redundancy consultation process, so it can be dealt with during that procedure. If it's not and it's completely separate, then it can be heard obviously alongside that consultation process, but it will be important to bear in mind the potential impact of the redundancy process in terms of employment coming to an end. Again, bear that in mind when you're dealing with this kind of situation. If you're in a situation where you are dealing with a grievance remotely, the ACAS code, the ACAS guidance has confirmed that is appropriate. Grievance meetings and investigations can be conducted remotely as long as the procedure is fair and reasonable. I guess some things to think about if you're doing that are making sure that the information is kept confidential and it's only accessible to those who it needs to be, those involved, that the data that you're dealing with is secure, making sure that in terms of virtual meetings taking place, that people have access to the right technology, because meetings will only be good meetings if people have the right technology in place for that to work. Also make sure there's no disruption from those who aren't involved. If people are having meetings virtually, they're taking place within their own home, and be sensitive to then people coming in and being part of that when they shouldn't be. Just on a final note, also in terms of managing things remotely, also making clear to employees that the meetings should not be recorded, and reverting them and reminding them any policies that cover that. What I would say as well is, remember, it doesn't change that, in normal practice, most of the time grievances, the best way to resolve them is by an informal discussion, and a lot of grievances can be dealt with in that manner. So don't forget that point, and that will apply as it would in a normal situation. That can still be possible if you're dealing with things virtually. For example, if all that's required is going to be a conversation between staff and mediate, type of mediation, that may well work if there are issues between colleagues. Talk about what an employee is looking for by way of a resolution, as you would ordinarily do so when you are faced with a grievance. And if it's not manageable to deal with it in the way they'd like, then look at alternatives and see what you can do. So it's not really that different from if you're dealing with it in a normal situation. So it's just looking at ways that things can be managed, looking at alternatives and adapting. And those kind of things will apply with another procedure, such as disciplinary, if you're dealing with allegations of misconduct. So just a number of things to think about if this comes up. So that brings this to a close. I will pass you back to David to finish off. Thanks very much.
Thank you both. Just a quick reminder from me on content on our website, useful and relevant content we've been delivering throughout this period and continue to do so. Articles, blogs, podcasts, videos, and all of the Q&A sessions are on there as well on our website, www.sintons.co.uk, and you can also follow the employment team on Twitter at SintonsHR. If you'd like to raise anything further that the team have discussed today, please don't hesitate to get in touch with them. I have, as usual, popped their details on the screen. If there's any other legal inquiry, obviously, please don't hesitate to get in touch with the firm. Our next session will be next Friday at 10 AM as usual, and I will pop the link round to you all after the weekend. From Keith, for Catherine, from myself, thank you once again so much for listening. It is a beautiful day outside. I'm on a half-day's holiday, so I plan to sit in the sun. So have a great day, have a great weekend, and continue to stay safe, and we'll speak to you next week. Thank you.